Thank you all for attending our inaugural 30-minute commercial webinar. Today, we're going to talk about avoiding commercial closing and title issues. My name is Maura Snabes. I am the SVP Corporate Counsel for Corporate Settlement Solutions, and we are pleased to have with us today attorney Gregg Nathanson. Just a little bit about Gregg, a little bit of his background. Gregg is a partner with the law firm of Cousins Lansky. He earned a bachelor's degree in history from the University of Michigan and a JD from the New York University School of Law. He is a member of the state bars of both Michigan and New York. His main areas of practice include real estate, environmental, corporate, finance, and business law. And he's also a licensed real estate broker. He has authored many articles and is a frequent speaker in his areas of expertise. Gregg has been recognized by Michigan super lawyers as one of the 5% best attorneys in Michigan every year since 2006. He was named as one of the top lawyers in Metro Detroit and selected as a top-rated lawyer in real estate by the American Lawyer and Corporate Counsel. Welcome, Gregg.
Thank you, Maura. Delighted to be here. And hello, everybody who's out there.
And just a note for our webinar participants, please feel free to type questions into the chat box at any time during this presentation for discussion, and I will read those to Gregg so that he can answer those. So Gregg, let's dive right into this. In your professional opinion, what makes commercial transactions so different and more complex than residential transactions?
So there's a lot of similarities, but there's a lot of differences as well. Residential transactions tend to be more straightforward. It's a matter of making sure you have good title, you can get financing, and you inspect the property and away you go. There's usually a form purchase agreement that the licensed real estate professionals will use. In a commercial transaction, it's much more complex. There's really not one standard form. In my practice, I use one form when I represent a buyer and one form when I represent a seller, just to sort of mold things to help protect them. The Commercial Board of Realtors actually developed a form. I chair their forms committee, and we put a form together, and we tried to strike a fair balance between what made sense in terms of pro-buyer, pro-seller. But the one thing the form really excels at is it's pro-broker. So if you're a broker and you're looking for a form that's going to protect you extremely well, I recommend you to that form. But in a commercial deal, problems can come from anywhere. You know, it could be a zoning issue, it could be a licensing issue, it could be a permit issue, it could be a governmental approval issue. Really, the problems can come from all over the place, which is why the purchase agreement is a critical document, you know, to protect your client.
Agree. Yes. And when you're working with a title company and they get these purchase agreements, they can't just process these as standard. They have to actually read the entire purchase agreement and every line of it so that they can process the closing correctly. So it's kind of like our Bible as a title company is the purchase agreement. What about the title commitment itself? Do you see any differences between the residential and the commercial type of exceptions that are on there?
Well, yeah, the structure is similar, but in a commercial deal, generally speaking, you're going to be more concerned with the Schedule B2 exceptions. Although I did have a deal recently where someone bought property and it was residential. It was in a very nice suburb called Birmingham, and the developer purchased 2 lots. He leveled the homes, and then he built 3 new homes. And our client was buying the home in the middle. So we were reading the building and use restrictions, which we were probably the first person to read them in 30 years. And I'm reading them, and it says 1 house per lot. And so I can count that high. And there were 2 lots, and our client was going to buy the 3rd house that was straddling the property line. So, you know, had we not read that, we wouldn't have known about this potential problem. We asked the seller, they missed it. They didn't know about it at all. And so what we ended up doing there is we ended up going to a title company that knew how to handle this. And I'm not going to name names, but this is one of the reasons why you want to have an excellent title company because they were willing to step up and insure against someone trying to enforce this restriction against our client. They did their appropriate research. They looked at the neighborhood. There were a lot of tear downs in the area, a lot of setback violations in the area by these large new homes. And based on that, it got to their comfort level that they would insure it. So again, it's critically important for the title company that you have in your court helping you.
Right. Yeah, you definitely want a title company with experience, and especially in the commercial sector, if you're dealing with commercial property, because there are those exceptions that we can insure over and some that we can't also. So are restrictions primarily the largest issue with Schedule B exceptions, or are there more commercial Schedule B exceptions that you find problematic when reviewing the title commitment?
Yeah, so good question. In a commercial deal, all kinds of things can come up. The restriction could be a building restriction. And particularly if it's vacant land, can the client build what they want to build? Because if it's vacant land, you have to look at the restrictions. Sometimes you need to get an architectural control committee or the initial developer. You need to get their approval for the project. Sometimes it's a use restriction. I had a situation where someone was buying property and the zoning was fine and it was going to be for adult entertainment, but there was a restriction recorded against the property that prohibited that use. So it's the type of thing you want to be able to, find out about. And then there's also something, there's setbacks. There could be setbacks that are in the recorded restrictions. So you have two levels of setbacks. You have the ones that are public, part of zoning, and then you have the private ones that are recorded against the land, and the property has to comply with both. And people don't always know that. So it's very important to read what's there. Occasionally you'll find something like a right of reverter, which could make you very nervous. There could be a reservation of mineral rights, especially for property up north, which is its own set of issues. So yeah, particularly in the commercial context, it's very important. In fact, I had a situation where a lender was refinancing a strip mall, and there was a liquor store and there was a bar restaurant. And we were looking at the restrictions. There was one from the 1920s that prohibited the sale or distribution of alcohol. So then it's like, okay, well, what do you do with this? Well, hopefully you have a good title company, someone who can understand it and help you address it. And I really can't overemphasize the importance of the title company, because some title companies, especially smaller agents, you ask them a question, the answer is no, and then they say, we've never seen that before, and then they say, well, what was the question again? Whereas a company like yours, where you're bigger and you're more experienced and you've seen things maybe 10 or 20 times, you're going to help someone get their arms around the issue and say, okay, this could be solved, and here's a couple ways to solve it. And if for some reason, let's say, for example, it's a tax sale where they bought the property and you just have to have a quiet title action, you would explain that as well. But at least they know they're going to have a knowledgeable reception and someone who could work as part of the same team to help solve the problem in a creative, cost-effective way.
Right. And I agree. I think it's important to have a title company that doesn't say no right off the bat, because a lot of times, not always, there is a way to insure over something or to remove something or to provide some affirmative coverage over a specific exception in the title commitment and policy. So yeah, you definitely need someone who understands that and is willing to work with you and resolve the issue to get you to closing. I think in your prohibition example, it was clear that could be insured over due to the fact that it was so old and the fact that it was during prohibition, probably it was put on and it had been violated for a number of years. So, underwriters, they say, what is the risk of someone coming back and bringing a lawsuit to claim that it's been violated? And that's what it is all day long, is decision-making and risk-making, basically. So I agree with that. What about surveys? Do you always advise the buyer to get a survey or Is it always an Alta survey if you do require them to get a survey? What do you advise?
So this goes back to your first question, whether it's residential or commercial and how the two differ. In the olden days, not to give away my age entirely, when someone would buy residential property, the lender would require a survey. And more recently, in residential transactions, most of the time the lender does not require a survey.
Mhm.
So the buyer who doesn't necessarily know what they're supposed to be looking for won't get one because the lender doesn't need one. But in a commercial deal, almost always recommend a survey because you never know what you're going to find. You're spending usually more money, and there's a lot of issues that you just wouldn't discover unless you had an Alta survey. I'll give you an example, if I may.
Mhm.
Had a client buying some property on sort of a well-known street in our area of the state, and it had an address with that street, and then it front, and then the side of the property was on sort of a slow public road. So when we got the survey, we were looking at it, and there was a curb cut, but none of the curb cut was on our client's property. So what had been happening is historically they'd been going over the neighbor's property to get to and from this main street. So, we approached the neighbor and said, we'd like to buy an easement. And the neighbor said, that sounds great. Get out your checkbook. How big a number can you write?
Right.
And of course, the lender was very motivated to get an easement because they didn't want to risk the issue of not having one. So in that case, the buyer and the seller split the cost of the easement, which is part of the cost of doing business. But the point is, if you didn't have the survey, you never would have known, and you wouldn't even have thought of it as an issue. And then one day the neighbor could put up a barricade.
Right.
And then you're into, okay, my access is blocked. And then can you establish adverse possession? Or is the neighbor going to say, well, no, this was permissive the whole time, and I gave the neighbor permission to use it. So you just can't use the property to access the main road anymore, which would have been a disaster for our client. So that's an example of something that a survey will reveal. Another example is a setback, which we talked about a little bit before. And it'll show is the building set back the proper distance from the property line. And maybe it is, and maybe it isn't. And we've had situations where the building was built and then the setbacks were passed. So it was grandfathered or grandmothered or grandparented.
Yeah.
Meaning at the time they did it, it was fine. And then the law changed.
Right.
So what the law says is, okay, you can continue with your legal non-conforming use, but if there's a change in the future, if there's a tornado or a fire or an expansion, you may need to build it to code and can't comply with that setback anymore. Sure. And if you didn't have a survey, you would never know that that's the type of issue that you were looking at.
Right. Great points. And I love the real case examples that you're giving. So on an owner's policy, typically, we do not insure matters of survey. So if they tried to file a claim due to that curb cut issue or that setback issue, we don't insure that either. It would not be a covered claim. Now, on a lender's policy, we typically give survey coverage without the need of getting a survey. Different underwriters have different limits. Some require on commercial deals a survey in every case. There are those that have, a limit as far as if it's $5 million or over, you need a survey, or if it's construction, obviously, you would need a survey just to make sure the footings and the buildings are being put on the right piece of property. Also, if we are insuring multiple pieces of property, it's my understanding you had a situation where there's a contiguity issue.
Yeah, so what happened is our client was selling. They had bought several properties over time, and the buyer got a survey, and they noticed there was a 3-foot gap that ran along the property line of 2 parcels. And the buyer said, well, I want a contiguity endorsement. I want to know all of these parcels have contiguous shared property lines. So our client had to go back to their seller. Their seller was dead. So, that obviously presents its own issues. So we went to the seller's child, and we agreed to pay for the cost to open a probate have the child appointed personal representative, have a court order issued authorizing the PR to give the deed, got the deed to the 3 feet. And then based on that, the title company was able to ensure ownership and ensure contiguity to help save the deal.
Yeah, that's great. And again, those things can happen. And if you don't have a survey, there's no way we would have even known about it. And from a title company's perspective, in order to issue that coverage, the contiguity endorsement, if you have multiple parcels, we do require the survey, obviously. Okay. That's the only way we're going to be able to tell if the boundary lines abut or not, whether there is a gap. So, Gregg, if you had to summarize the 3 most important things for an attorney or a realtor and a lender to do in a commercial transaction, what would it be?
So the 3 most important things, first, I would say assemble a strong team, because the attorney, the broker, the title company, the lender, the surveyor, the environmental consultant, I see them as all part of the same team, trying to protect the client and help the client achieve their goals. So you want a strong team. Again, as we mentioned, you want an environmental consultant who understands their business. You want a title company who understands their business. Because if you're dealing with professionals, you're more likely to solve problems. Secondly, it's important to have a checklist and stay organized. When we start a transaction, we'll put together a checklist. Usually it's more important on the buy side, but it's important on both. And then we'll have a meeting or circulate it and then say, okay, here's the 33 possible issues. Which is the attorney handling, which is the client handling, which is the broker handling, which is the title company handling, which is the lender handling, and which is the client going to just sort of let go because they're not overly concerned about it. But at least at the get-go, you're organized. And you know, okay, these are the issues, who's going to attack them. The advantage of doing that is you're less likely to have something fall through the cracks.
Right.
And the third thing is clear and consistent communication. For people who are talking to each other, they're emailing each other, they're doing Zoom calls, they're having meetings, whatever it might be. Again, to make sure that nothing's falling through the cracks and everything's being covered, because it's easy to make assumptions. But as you know, there's really no substitute for clear communication.
Yeah, I agree. And without that communication, people inevitably think about worst case scenario. Why haven't I heard from the title company? Why haven't I heard from the attorney? What's going on? Why is the surveyor taking so long? Nobody's communicating with me. So they think the worst case scenario, and they think that you're not working on their file, that you're not thinking about it. So definitely that proactive communication is key. And as far as being a team, I agree. I think you're working with a team and you don't have to be an expert in everything. As long as you surround yourself with the other experts in their area, that just makes everyone look good, feel better about the transaction. You had mentioned something about environmental concerns. Tell me more about that as far as whether that is a major consideration when we're talking about from a buyer's perspective versus a lender's perspective.
So environmental is critical in almost all commercial transactions. In residentials, you might have a lead paint issue or an asbestos issue or a radon issue or a black mold issue. These do come up. But on the commercial side, in most transactions, there's a regimen you can follow. Get what's called a phase 1 environmental site assessment. And if it determines there could be a problem, which they call a recognized environmental condition or REC, then you do a phase 2. The phase 2 tests the soil, the groundwater, and sometimes the air. If they find contamination above a certain level, then the buyer or occupant can protect themselves by getting what's called a BEA or baseline environmental assessment. And then the last piece is something called a due care plan. The due care plan, I'll give you an example. Okay. We had a client that bought a medical office building not long ago, and they did a phase 2, and in the soil, they found mercury. So there was a concern that there might be an indoor air issue with mercury. And of course, the seller said, there's nothing to worry about. I've been here. I've had no problem. Let's just close. The buyer's like, well, I think we need to do some testing. So they did a test of the air and they found no problem. Seller said, great, let's close. Buyer said, not so fast. Our consultant is telling us we need 4 quarterly tests that are negative. And not only that, if one of them is positive, we have to put in what's called a sub-slab depressurization system. It's sort of like what you'd see for radon, where it vents the air out into the atmosphere. But that's not all. Because it's mercury, you can't just vent it into the atmosphere. You have to put a special filter on this system. So what we ended up doing is getting a quote from an environmental consultant that said, and they agreed to hold the quote open for a year. They said, we will do the next 3 quarters of testing. And if there's a problem, then we will install this system, this remediation system with the filter. And that way the seller got to sell and held some of the money back. The buyer got to buy and occupy the property. And it was unlikely there'd be a problem. But if there is one, the buyer doesn't have to chase the seller because the money's sitting in escrow, and they don't have to scramble how much is this going to cost and who's going to do it, because we already had the proposal set aside. So that was a way to manage an environmental issue. And in this situation, the buyer who didn't have the problem necessarily to clean up the mercury because they were getting a BEA, but because it could potentially pose a threat to human health or the environment, they had this due care obligation to make sure that that didn't happen.
Right. And that brings you another way to get to closing earlier, to escrow for, again, worst case scenario, if we needed to do that. So again, another resolution by whatever title company you used to agree to do that. So,
and I'll give you another example. There was a case, wasn't my case, but there was a case in 2010, the state passed a law called the Commercial Real Estate Broker Lien Act. And what that law does is it says if you're a commercial real estate broker, you have the right to record a lien against the property to secure payment of your commission. So residential brokers don't have this right. Commercial do. You can always get it consensually by putting it in your listing agreement. But the statute gives it just like a construction lien, where the law says if you're working on a project and you're supplying the bricks or the labor, then you have construction lien rights. So this was a situation where the broker felt like, and they rightly felt like they're getting frozen out of the deal. So they recorded a lien. And what the statute said, so of course, the title company saw the lien, the lender freaks, right? It's like, we're not going to close with a lien on here. And so the buyer wasn't too happy about it. So what the statute says is if you escrow an amount necessary to satisfy the lien, then the lien can get released. So in this situation, the lien was for 60 grand. So the parties escrowed 75 grand, saying that was sufficient. It enabled the title company who was holding the 75 grand to insure over the lien and insure the buyer's purchase and the lender's mortgage. And then the broker who had recorded the lien, they lost their lien, but here they had this pot of cash that they could go against. So that was another way to solve the problem, get the deal moving forward.
Right.
Yeah. Creative solution.
Yeah. Usually there's always a resolution or a solution that, as long as everyone's on the same page and can be mutually agreed to, you're all set to go to closing. I can't believe it's already 12:25. So one last question that we'll get into our questions from our attendees. So what is the most unusual thing that you've seen happen in a commercial transaction that you can recall and would like to share?
Well, putting aside COVID, which has been quite bizarre.
Right.
I had a situation early in my career where we were representing a seller. And so I went to the closing, and the seller was very talkative. And there were 2 people on the buy side. One was there, and the other we were waiting for. So the parties signed everything. We put the documents in a big pile in the middle of the table, waiting for the second buyer to show up. And the buyer that was there asked our client questions, and he gave answers that made the person uncomfortable. Person asked more questions. gave more answers. And I sort of kicking the guy under the table. I ended up finally, saying, excusing him, saying, "Can you please talk to me outside? I have a question for you." And it's like, stop talking. He just couldn't help himself. And the more he talked, the more it made the buyer uncomfortable. So the second buyer came, the two of them caucused. They picked up the documents. They said, "We need to think about this." They walked out. Deal never closed.
Wow. So what is your advice to your client? Don't talk in a closing. Wait until all the papers are signed, or
muzzle the client. Seriously. Yeah, I mean, if you're on the sell side, you want to be very protective in what reps and warranties you let the seller make. And these days, it's unusual to have the seller and the buyer in a room together.
It is.
Closing a transaction. In the olden days, it was much more common.
Absolutely.
Now it's the battle of disclosures and reps and warranties really fought more in the purchase agreement than in the presence of people these days.
And obviously, we want our clients, our customers, to be honest in their affidavits and anything that they disclose. We don't want them to hide something because, it's not legally, ethically, or morally correct to do that. But
right.
But yeah, so we do have a question. In the example of a dirty phase 2 ESA, where a BEA follows, and there is also a due care plan, can you please elaborate on where liability ultimately falls and the proper steps to take by buyer and or seller?
So, it depends. Great question. Depends which side you're on. The purpose of the BEA is to protect the buyer or the occupant from liability to clean up existing contamination. The purpose of the due care plan is for the buyer or the occupant to take whatever steps are necessary to avoid an unreasonable risk of exposure to human health or the environment. So it depends on what chemicals. When we say dirty, it's a dirty site. It's a question of, well, can you leave it there? And let's say if it's getting into the groundwater, is the groundwater being used on site, or is it connected to city water so you don't need to worry about it? Is it a contamination level where the state feels it needs to be cleaned up, which would probably then be on the seller? Or is it contamination, which is often the case in property, especially where there's a lot of clay in the soil and it can't migrate, that you can just leave it there and you manage it by having maybe restrictions against the land, saying, if you want to, you record something when you get your BEA. And it would say, for example, it's an engineering control. And you might say, okay, you can't use the floor drains. You got to stop them up. Or you record something against the property, limiting its future uses. Or if you're going to build an addition in the future, you have to test the soil. And if the soil is contaminated, you have to ship it off to, a certain landfill that's licensed to handle it. Mm-hmm. So a lot of it goes to the nature of the contamination and what the law requires. But the parties between themselves have some ability to contract in terms of the seller reps and warranties and indemnities as well.
Right. Yeah, they do, but that doesn't mean the state has to recognize that, right?
Right, exactly.
So typical attorney answer, it depends, right?
Yes. Well, it does and it doesn't.
Yeah, it does. Yes. We know what the state says. We know what the laws say. And yeah. We have one more question. What, as an attorney, when you represent a buyer or a lender, what are the most common endorsements that you request be issued?
Well, that's a great question. I ask for everyone that's free. If I represent the buyer, I ask for everyone that's possible when I represent the lender, because the buyer's paying for them.
Such as any, any ones that stand out in your head? Yeah,
so same as survey is usually at the top of the list, because a lot of times the legal description is long and complicated. If it's like lot 102 of an industrial park, not as concerned. So long meets and bounds legal description, I want a same as survey endorsement, so I know what I'm seeing on the survey is what I'm getting on the long legal description. It's good to get tax parcel number. Often will ask for location, ask for contiguity if there's more than one parcel, covenants, conditions, and restrictions, mineral rights, subdivision if there's some concern about a land division issue, and then if there's, let's say it's a Taco Bell or McDonald's, and they're going to have a long-term lease, maybe a ground lease. They're going to build the building, and then they may tear it down in 10 years and then rebuild it. And the lease could be 20 years with 5 20-year options. The bank's making the loan. You can get a title policy. You know this more. I don't know if everyone knows this. You can get a title policy ensuring the leasehold interest.
Mm-hmm.
So
Right.
if it's a serious leasehold interest, it makes sense to get your title commitment, see are there mortgages, are there judgments, are there tax liens, does the landlord really own the property, and title insure it. And in
Right.
some cases, you can also insure an option to purchase.
Mm-hmm.
So those could be very important endorsements as well.
Right. Yes, we issue leasehold policies all the time for
Mm.
those long-term leaseholds, holds, especially on the commercial side of the transaction. So, and some of those endorsements that you mentioned, we need a survey in order to issue. Some of them we don't. And some of them, as you mentioned, have a charge associated with it, and some of them don't. So all good information. It looks like we have answered the questions, and it's just a little bit over our half-hour mark. So I want to thank you again, Gregg, for joining us and your expertise, sharing that with us and some stories. And thank you to all the participants. If you have any other questions that you may have or think about after this webinar, feel free to email myself or Scott Schmunk, and we're happy to pass those along to Gregg. Thank you so much. And
Thank you for the opportunity as well. I appreciate it.
Absolutely, our pleasure. And hopefully all our participants will see you next time when we give our next 30-minute commercial webinar. Have a great day.
Thank you.
All right, bye.